Hello, and welcome to Argyle CISO Leadership Forum, the evolution of information security. My name is Nick with Argyle, and it's great to have everyone joining us today. I have some important information to share with you, and then we will turn the floor over to our esteemed keynote speaker. First, a quick reminder to stop by our sponsors' virtual booths at any time during today's event and for the following week. Our partners are committed to providing you with valuable content and a great overall experience. At any time during today's event, you can visit their virtual booths from the main agenda page, which include complimentary materials, information, and meet and greet opportunities. To ask questions throughout the session, simply type into the Q&A chat, and we will address your questions at the end of the session. Now, without further ado, I would like to introduce our speaker, Patrick Burke, Counsel, U.S. Privacy, Data Protection, Cybersecurity, and FinTech Practice, Norton Rose Fulbright. We are all excited to have Patrick for his keynote presentation titled Regulatory Republic, an Information Security Compliance Update. Welcome, Patrick. Over to you.
Thank you so much, Nick, and welcome everyone. I've been asked to provide a global overview of new developments in information security compliance. And there is plenty going on. New compliance obligations are going into effect and more in the works. You won't be too surprised that many of the new cyber requirements come under the banner of privacy or data protection, as consumer protection tends to drive the politics of enacting these provisions. And of course, the two go together. The big global picture shows that cyber regulations in the past were mostly an afterthought, tacked onto data privacy regulations, and tended to be vague, like the standard for cybersecurity in the California Consumer Privacy Act, the CCPA, which requires reasonable security. That's changing, at least with respect to more sensitive economic sectors and critical infrastructure, as we'll see. The data privacy and data protection laws around the world have followed the global leader, which is the European Union. And the GDPR's Article 5, principles relating to the processing of personal data, and Article 32, security of processing, are also not very detailed. But essentially require appropriate technical and organizational measures, that's a phrase we're going to hear again, to ensure a level of security appropriate to the risk. So it's a risk-based approach to regulation. It allows organizations to conduct risk assessments and then put controls in place as appropriate. And as we'll see, however, the UK and the EU are getting more detailed in their cyber requirements, particularly for certain sectors. So let's begin with a look at developments in the United States. US has traditionally had political difficulties passing comprehensive national privacy or cybersecurity requirements, both because pro-business legislators want to protect companies from expensive requirements, and consumer advocates like what the activist states are doing, and they fear federal preemption. But the Democratic Congress and federal agencies have begun moving quicker on what regulatory requirements they can with respect, in particular, to critical infrastructure. The Transportation Security Administration, TSA, has been actively plugging some security vulnerabilities. It issued security requirements for pipelines, airlines, and railway operators, requiring reporting of incidents to the Federal Cybersecurity and Infrastructure Agency, Security Agency, CISA, which we'll continue to hear more about over the years. We've been working hard on those requirements with our clients, so that's been a big effort. Last month, they issued new requirements for passenger and freight railroad carriers. Congress does seem to recognize critical infrastructure deserves enhanced cybersecurity protection, and in 2022, Congress passed and the president signed the Cyber Incident Reporting for Critical Infrastructure Act of 2022. The Federal Cybersecurity Infrastructure Security Agency, CISA, is putting together regulations pursuant to the act It focuses mostly on notification requirements, including notification of the payment of ransoms within 24 hours. Earlier in the year, the SEC proposed new security disclosure requirements, including disclosing the board's expertise in assessing and managing cybersecurity risk and implementing policies and procedures. And as we'll see on the next slide, while the SEC is proposing requiring companies to disclose the level of cybersecurity expertise on a board, New York DFS is requiring that boards actually have such expertise. At the bottom of the slide, you'll see various state privacy laws which go into effect in the coming months. Big news being the California Privacy Rights Act, which goes into effect in January, with enforcement coming live in July of 2023. The story of 2022 for the US is increased regulatory scrutiny and enforcement, but likely it's just the tip of the iceberg of what's to come in terms of future enforcement actions. In the US, California and New York continue to lead the way on new cybersecurity requirements and enforcement actions, but they're probably only warming up. New York has put some actual cybersecurity best practices into the law books in its New York Privacy Act of 2021, while most of California's cybersecurity standards run to reasonable security, but there's reason to think the newly created California Privacy Protection Agency will begin to push much harder on cybersecurity preparedness, if only because their executive director is Ashkan Sultani, who is very, very, very technical. He began as a researcher. In 2009, he documented the use of zombie flash cookies by several online networks and ended up working at the Federal Trade Commission in their Division of Privacy and Identity Protection. And while his focus likely will be trained on the use of ad tech, he also has the chops to move cybersecurity standards along. Speaking of the Federal Trade Commission, here they are at the top of our slide. In the interest of time, I'm not going to discuss each of these enforcement actions and settlements. I'll focus instead on where they seem to be moving and also on one cautionary tale for our esteemed audience. So on May 20th of 22, the FTC's Privacy and Identity Protection Division, again, where Ashkan Sultani worked before he joined the California Privacy Agency, published a blog post called Security Beyond Prevention, the Importance of Effective Breach Disclosures. And in the post, the FTC takes the position that in some cases there may be a de facto data breach notification requirement, despite that there currently is no section of the Federal Trade Commission Act or implementing regulation imposing an express, broadly applicable data breach notification requirement. So businesses should nonetheless take this de facto rule into account as part of their incident response plans. And now the cautionary tale. 2022 was a year that a chief security officer at Uber was found guilty by a San Francisco jury on felony charges for his attempted cover-up of data breaches. So given the audience, I think this man's story is worth remembering. So Joseph Sullivan had been hired as Uber's chief security officer in 2015, just as the FTC was investigating a serious data breach at Uber that took place the year before in 2014. The month after Sullivan was hired, the FTC's Division of, guess what, Privacy and Identity Protection, served a detailed civil investigative demand on Uber, demanding extensive information about any other instances of unauthorized access. Sullivan played a central role in responding to the FCC, including testifying under oath in November 2016. 10 days after his 2016 FTC testimony, Sullivan learned that Uber had been hacked again. The hackers reached out to Sullivan directly via email and others at Uber, informing them they had stolen a significant amount of Uber user data and they demanded a large ransom payment in exchange for their deletion of the data. Employees working for Sullivan quickly verified the accuracy of these claims, and the massive theft of user data, which included records on approximately 57 million Uber users and 600,000 driver license numbers. So a really big data breach. But rather than reporting the new breach to the FTC or any other authorities or Uber users, Sullivan executed a scheme to prevent any knowledge of the breach from reaching the FTC. For example, Sullivan told a subordinate that they can't let this get out, instructed them the information needed to be tightly controlled, and that the story outside of the security group was to be that this investigation does not exist. He then arranged to pay off the hackers in exchange for them signing a non-disclosure agreement, which the hackers promised not to reveal the hack to anybody, and also contained the false representation that the hackers did not take or store any data in their hack. Uber paid the hackers $100,000 in Bitcoin in 2016, despite the fact the hackers had refused to provide their true names. So Uber eventually was able to identify the two hackers a couple months later and required them to execute new copies of the non-disclosure agreements in their true names, and emphasizing they were not allowed to talk about the hack to anyone else. In the meantime, Sullivan continued working with the Uber lawyers, handling and overseeing the previous cyber inquiry, including the GC of Uber, and never mentioned the incident to them. Instead, he touted the work he and his team had done on data security. So in fall 2017, Uber's new management began investigating facts surrounding the 2016 breach. When asked by Uber's new CEO what had happened, Sullivan just lied, falsely telling the CEO the hackers had only been paid after they were identified, and deleting from a draft summary prepared by one of his reports that the hack had involved personally identifiable information and a large quantity of user data. Sullivan lied again to Uber's outside lawyers conducting an investigation into the incident. Nonetheless, the truth about the breach was ultimately discovered by Uber's new management, who disclosed the breach publicly and to the FTC in November 2017, a year later. The two hackers identified by Uber were ultimately prosecuted and pled guilty, and disclosed how Sullivan had assisted in covering up the breach, which gave them a chance to hack another company. So Sullivan, who was convicted earlier this year, faces a maximum of 5 years in prison for the obstruction charge, and a maximum 3 years in prison for the misprison charge. And with that, Joe Sullivan is now the poster child for how not to handle a cybersecurity incident, particularly full-on lying to the FTC. Let's turn to the New York State Department of Financial Services, which regulates banks, insurance companies, and about 400,000 other financially oriented businesses, and where I used to serve as deputy superintendent in the supervising examinations for compliance with the cybersecurity regulation. So they implemented their cybersecurity regulation in 2017, very comprehensive, very groundbreaking. Back then, we did not bring many enforcement actions for violations of the cybersecurity regulation. We were more in an educational mode, getting people to adopt better practices. But that has changed, as you can see. DFS just recently proposed amendments to its cybersecurity regulation, tightening it up. Among the proposed changes is to create a new regulatory class of licensed or chartered companies called Class A companies, those with over 2,000 employees or over 1 billion in gross annual revenues over the last 3 years. And those companies will have heightened cybersecurity obligations. So that's an innovation, makes sense. And here's where we remember the SEC proposing requiring boards to disclose their cybersecurity expertise. So DFS has doubled down on that approach with a new requirement that each company's board must have sufficient expertise and knowledge or be advised by persons with sufficient expertise and knowledge to exercise effective oversight of cyber risk, and a committee or subcommittee assigned responsibility for cybersecurity. The proposed reg has added a requirement that the board also needs to provide oversight and direction to management of the covered entity's cyber risk management program. In the meantime, New York State Attorney General is moving ahead on enforcement actions and settlements with the aid of New York's Privacy Act of 2021, which includes cybersecurity requirements. Let's leave North America and move on to the Asia Pacific region. This chart provides an overview of the legal landscape, and I've highlighted developments in the past year, mostly the implementation of more stringent data privacy laws. I want to take a minute to consider what India is doing. Keeping in mind many companies from the US operate facilities in India, particularly related to data, India's Computer Emergency Response Team, CERT-IN, which falls under India's Ministry of Electronics and Information Technology, issued directives that mandate a good deal of cybersecurity common sense, like enabling logging, retaining logs for 180 days, encouragement of security operations center solutions, and working with trusted MSSPs. It also requires that incidents be reported to them within 6 hours. 6 hours. So that's new and different. Let's go to, yeah. This is actually Australia, where there's quite a bit going on, and I am going to not cover them. I want to make sure I got this slide to you. This is a real catalog of the most important cyber-related laws in Asia, and I think it's just a good resource for you to have. That was Australia. Let's talk about the UK and the EU, kind of get back around the other side of the world. Under the GDPR's Article 5 and 32, which require having appropriate technical and organizational measures, TOMs, as we call them, we're seeing more enforcement activity in these areas from European data protection authorities and the UK's Information Commissioner's Office, the ICO. European financial service regulators, including industry regulators such as Lloyd's, are looking more closely at TOMs. Note that Lloyd's recently reported it had its own breach. The EU data protection authorities have also sidestepped away from its former promise of a regulatory one-stop shop. The idea that the home regulator in the EU member state where companies have chosen to be headquartered would handle all of your regulatory needs, investigations, one-stop shop. This has led to squabbles among regulators, for example, some accusing Ireland of going soft on supervision and enforcement to encourage companies to headquarter themselves in Ireland. Well, that's changing in a couple ways. First, companies from outside the EU and UK who once had to report incidents only to the DPA in the member state they chose as the European base, like Ireland, now must report incidents to all the member states where individuals were affected. Second, DPAs like Ireland are beginning to decline accepting jurisdiction as the lead supervisory authority, which has resulted in multiple parallel investigations in different member states for the same incidents. Then there's Brexit. As if jurisdiction was not already being confused, there's an added level of confusion for companies based in the UK who also operate in the rest of Europe. No more one-stop shop for them. It also sets up a situation where UK law is beginning to diverge from the GDPR, which creates risk and difficulties handling transfers involving both the UK and the EU. There's also an increase in claims for compensation following significant breaches, which in the US, they often turn on questions of damages. So courts are now dealing with these claims, and the Court of Justice of the European Union recently limited the scope of non-material damage, and the UK courts have imposed de minimis thresholds for injury. So if I were to glean UK-EU regulatory priorities, it would be these. I'm not going to go through these in detail in the interest of time, but these are the challenges we encounter when working with European data protection authorities and the UK ICO on behalf of clients. You see the list of issues along the left, which we see is coming up frequently. You also see on the right those TOMs I mentioned earlier. They're increasingly expected, and regulators are now sophisticated enough to analyze a breach and determine weaknesses in the TOMs, and that can lead to fines. I want to direct your attention to the Cyber Resilience Act proposed by the European Commission in September. Again, another sectoral set of requirements, but in this case, the sector is for manufacturers, developers, and distributors of products with digital components. Covers both hardware and software, so that's quite a sector. The overall goals are to develop more secure products and software, which is smart, and keep consumers informed. This will necessarily focus manufacturers on these requirements from the time they begin engineering future products and continue long after a product has been released, continues through the product life, and includes provision of information to customers on how best to keep safe. The CRA complements the EU's Network and Information Security Directive number 2, called NIS2 directive, which is also going through the EU legislative process. And it will repeal the current NIS directive and will amend the rules on the security of network and information systems. In particular, NIS2 directive will expand the scope of entities required to comply with the rules, specify minimum technical, operating, and organizational measures, and streamline incident reporting obligations in order to avoid over-reporting. I'll give just a little more on the CRA because I think it'll make you appreciate the greater sophistication of the rulemaking, and also because it's just going to be a major development and could have an effect on the world's supply chain issues. So essential cybersecurity requirements. So products with digital elements will only be allowed on the market where they meet the essential cybersecurity requirements. So those requirements are high level, they're drafted broadly, they're not novel, but rather they codify existing good practices. For example, products must protect the availability of essential functions, including the resilience against and mitigation of denial of service attacks, that kind of thing. Number 2, vulnerability handling requirements. Manufacturers of products must also comply with various requirements relating to the handling of vulnerabilities. They must have appropriate policies and procedures in place to ensure vulnerabilities are appropriately addressed. So for example, once a security update has been made available, manufacturers must publicly disclose information about fixed vulnerabilities and have a policy in place on coordinated vulnerability disclosure. Third one, extra requirements for critical products. So while all products in scope of the CRA must undergo a self-certification conformity assessment procedure, so that's a process of assessing whether the product complies with the relevant standards. Critical products must undergo a more formal assessment with the involvement of a central EU body selected by the member states' national authorities. So they divide critical products into 2 classes. Class 1 include identity management system software and privilege access management software, passport management, network traffic management, and Class 2 products cover operating systems for servers, desktops, and mobile devices. So both classes require an assessment of the technical design and development of the product by a central EU body who will test it, followed by self-assessment and conformity by the manufacturer, or full quality assurance assessment by the central EU body. So products that don't fall within the definition of critical products may alternatively be assessed based on the manufacturer's own internal control without direct assessment by a notified body. So all to say, for example, you may have seen the last few days, there was an article story about some Russian software that was fraudulently pretending to be American software. And it was found at the U.S. Army and the Center for Disease Controls. So it happens. Conformity of products and information, instructions to users, technical documentation must be drawn up before the product is placed on the market. It has to be continually updated during the expected product lifetime or 5 years after the product has gone on the market. There's reporting obligations. Manufacturers must notify the European Agency for Cybersecurity without undue delay, and in any event within 24 hours of becoming aware of any actively exploited vulnerability contained in the product. And then obligations on the rest of the supply chain. Distributors and importers also have obligations under the CRA to ensure that non-compliant products from overseas don't make their way to the EU marketplace. So there are various procedures for that. They must also inform the manufacturer if they identify a vulnerability on the product. In terms of enforcements, the European Agency for Cybersecurity will have oversight of the CRA on the EU-wide level. It'll receive notifications from manufacturers of actively exploited vulnerabilities and prepare biennial technical reports on emerging trends. On a national level, CRA will be enforced by market surveillance authorities. These authorities will be designated by national governments and could be a newly created body or an existing one, could be the data protection authorities. And they'll have the power to order the withdrawal or recall of a product from the market and impose monetary penalties up to the greater of 15 million euros or 2.5% of the total worldwide annual turnover. Entry into force, it's going through the usual ordinary legislative procedure right now. Once it's adopted, organizations will have 2 years to comply with the new requirements. And what about the UK? They're no longer a member of the EU. It won't be bound by these new rules. However, the UK is in the process of passing a similar piece of legislation called the Product Security and Telecommunications Infrastructure Bill. And it's at the report stage in the House of Lords, meaning the bill has almost completed its legislative passage. So my take on this is that many of the essential cybersecurity requirements simply mirror good practice, and therefore many companies will not have significant work to do in this area. The complex piece is around working out which type of conformity assessment products may require and producing and updating a raft of policies, procedures, and other documentation that CRA requires. Reporting obligations under the CRA will add burden to companies already facing reporting requirements under the data protection laws, the NAS directive, and other sector-specific legislation. Reporting obligations on distributors and importers may also create tension in the supply chain and during contract negotiations, as manufacturers will undoubtedly be nervous about distributors and importers reporting products, potential vulnerabilities to market surveillance authorities. So now I'll hand it back over to Nick and we'll open it up for questions.
Oh, thank you so much, Patrick. We're not going to have time for questions, but I wanted to thank you very much for such an insightful presentation. I want to thank everyone for joining us today for this fantastic keynote. This session, along with all of today's content, will be available on demand following the event. But thank you so much, Patrick.
It was a pleasure. Have a good day, everyone.